Good day. My name is Andrew Holmes, the brand director for Goslings Rum, joining you here from Bermuda. We're in Goslings production and aging facility in the city of Hamilton. We're very excited to be navigating the dark and stormy waters of trademark and copyright for Global Bar Week. So we're going to start by introducing a little history on the Gosling family and the cocktail, the Dark and Stormy. So the Goslings are the oldest business here in Bermuda, and now 8 generations of the family involved in running the business. Goslings is known for the Dark and Stormy, which is made with our flagship Goslings Black Seal Rum and ginger beer. Goslings Black Seal is a blend of rums from all over the West Indies, aged in once-used bourbon barrels, and very popular here on the island of Bermuda and internationally. The name Black Seal comes from when Goslings used to age the rum in barrels and sell it on draft. They had no bottling facility whatsoever. So customers would go into the store with their own bottles and fill up right out of the barrel that the rum was aging in. After World War I, Goslings began recycling old champagne bottles very similar to this, which they got from the British Navy stationed here in Bermuda. They said they cleaned up the old champagne bottles and began filling them with rum, corking it, and sealing it with black wax. The rum was originally called Old Rum, but locals began to nickname it the Black Seal. So it was actually a gentleman by the name of Francis Gosling who illustrated the barrel juggling seal as a play on words for the wax seal. It has nothing to do with our seal population here on the island. Goslings Black Seal Rum is the #1 selling spirit in Bermuda and the #1 export from the island. They began exporting the rum in the 1980s, and it was June 9th, 1980, that Goslings first trademarked the Dark and Stormy cocktail here in Bermuda. So 2020, we celebrated 40 years of the trademark. I'm going to show you how we make a Dark and Stormy here on the island. We start with our barrel mug, which represents the barrels that the rum is aged in. I'm going to fill that with ice. And then first, we're going to add Gosling Stormy ginger beer. Stormy ginger beer was started to manufacture in 2009 and is now sold all over the world. So in goes the ginger beer. And then make sure we save enough room to float Goslings Black Seal Rum right on top. When the rum floats on top, it looks like a storm cloud, which is where the name Dark and Stormy originated. Now, Dark and Stormy is best enjoyed with a slice of lime. So we're going to add a little bit of a lime wedge in there, and the citrus from the lime helps to balance the sweetness of the ginger beer. So I like to squeeze it right in the glass and enjoy. Cheers.
Cheers.
Now I'd like to introduce our presenter. Daniel and I first met at Tales of the Cocktail in 2019 in New Orleans, where we're presenting the trademark seminar with one of our mutual friends, Mr. Eric Castro, bartender at large. So Daniel, as I described earlier, is an OG of the craft cocktail movement and was one of the opening bartenders at PDT in New York, then moved to LA, where he's originally from, to open Varnish. And then he took the wrong bar exam and has a very unique perspective, having worked as a bar director and as well as having a law degree. So it's a very unique angle. After his law degree, he came back to the business, thank you, Daniel, as the general manager of the Normandy Club and the Walker Inn, and he is currently a managing director and partner of the West Side Hospitality in Hong Kong and Second Ward Hospitality in Austin, Texas. So I would like to introduce Daniel to start our presentation on the trademark. Please.
Thank you, Andrew. That's a great intro. And I wish I was in Bermuda with you right now, enjoying some. But fortunately, home office it is. So I guess we'll start with the basics. Start with what is intellectual property. Like what's the legal definition? Why do we care? So intellectual property basically refers to any creation of the mind, inventions, literary works, artistic works, designs, symbols, used in commerce. Primarily, legal precedence has divided them into 4 categories. We have patents, copyright, trademark, and trade secrets. And they're all protected by law to different degrees and under different kind of parameters. Patents, obviously, most of us know, refers to inventions. They're design patents, processes, physical inventions such as machines, like the patent for a personal computer, for instance. Copyrights provide authors and creators of original material the exclusive right to use their material, right? To copy their right, the right to copy their work. That would be books, paintings, pictures, music, and that kind of sort. Trademarks are marks that are used in trade. But we're not really creative with naming things in the legal field. So it's any symbol, phrase, insignia, logo that kind of differentiates your product from any other product. Probably very big examples would be the Nike swoosh, right? Or the Coca-Cola logo. And lastly, trade secrets is any company process or practice that's not public information. And they have to be actively protected by the company, and it's some kind of secret that gives your company an edge on the rest of the competition. Kind of like a really easy example, again, to go back to Coca-Cola, would be the Coca-Cola formula, right? Nobody really knows it. It's a trade secret. That way no one can copy Coca-Cola. I guess it bears into question, why does it need protection, right? Why not just share information freely? And I guess in an ideal world and everyone was altruistic, that might be the case. But innovation is costly, right? Research is costly, development is costly. And in a business world, if IP rights weren't protected, people would stop inventing things. It's part of what makes human progress is this, need for innovation and to invent. But once things are invented, it makes sense in a policy way to protect those rights, at least for a little while, so that the inventor can recoup their, R&D costs and have it, if you've invented something new and you have an edge, it makes sense to protect that edge, at least for a little while. It helps basically drive commerce. And then, but why should we care as bartenders, as bar owners, and as professionals in the hospitality industry? Basically, a lot of money is potentially at stake. Recipes and techniques used to be very well protected back in the day. If you go way back before Jerry Thomas, wrote the first cocktail manual, bartenders didn't freely give away their secrets. The recipes were highly guarded, techniques were highly guarded. And, when you quit or got fired, you took those recipes and techniques with you. And, if there's a young bartender that wanted to come up the fray, he had to earn those recipes. And that's why it was such a huge deal when Jerry Thomas wrote the book that he did, because he was revealing these trade secrets to the world. And I remember back in the early days when craft cocktails came up, bartenders had their little notebook in their pocket, and you were very lucky if a bartender took you under their wing and opened that book up for you, and you had maybe an hour after your shift to copy and memorize as much as you could until your next shift, and go home and rewrite it, and you had your own little notebook. Obviously things have changed. I think a lot of us have become used to things, a lot of information being free, especially online. There's a lot of great blogs out there, a lot of industry leaders that share their knowledge very freely. And it's one of those things that are conflicting in our industries, like, should these things, be protected or not? But, to be fair, especially in this day where there is a lot of money on the line, where consultations are a thing, where, recipe development is very important and can differentiate one bar over another. right? And training manuals, training manuals, recipe consolidation, even having compendium. It takes a lot of time to prepare, to write. And if someone quote unquote steals it, there's a lot of time that one should be compensated for. Maybe, right? That's the question kind of that we are asking. This kind of was really spurred by a article that John DeBerry wrote on recipe theft, like what constitutes recipe theft and why aren't there more legal protections, or are there legal protections? It was Eben, he said in an article in the Atlantic that in no other creative business can you so easily identify money attached to your creative property. There's an implied commerce to our intellectual property, yet we have less protection than anyone else. Basically, he was alluding to the fact that recipes are not copyrightable. And so if he puts a recipe out there, he was talking about fat washing at that point, and a bunch of people copy it, right, and make a bunch of money off of it, there's no legal recourse for him to come after them and be like, hey, that was my idea. Even if you take a recipe from another bar and that cocktail becomes the number one, selling cocktail, probably don't have a lot of legal recourse. Again, if you're the originator of the cocktail, whereas with it's music, a painting, a book, all of these authors and creators do have a legal avenue to get paid off of their creation. So before we talk about how to protect a recipe, first we got to make sure that you own that said recipe. And for many working bartenders, if you create a recipe or a cocktail within the scope of your employment, basic IP law states that the place of your employment actually owns the IP rights to said cocktail. It's work property. It's during your course of employment. That's why you get paid what you get paid. And that's, something that you should keep in mind as a bartender. Also as a bar owner, it's the same thing if, again, if you're like a programmer and you create code during your employment at Google owns the code, right? You don't actually have any IP rights to it. So first, let's make sure that, you own the IP to what you think is yours. A lot of it comes down to agreements with contracts, right? It's very uncommon these days for employment agreements to be negotiated in that manner. But if it is a position that you're coming into as, a higher, more senior member of a team, it might be something you write into your contract, where, recipes that are developed under yourself, you retain some sort of rights to. It would be very similar to a music contract where, you don't own your masters if you have a studio, unless you negotiate those rights. So that's, let's first make sure you kind of own the recipe. Let's say you do own the recipe. One of the most kind of traditional ways recipes were protected, because they can't be protected, necessarily under copyright, was the trade secret route. Things like the Coca-Cola recipe, like I said before, or the KFC special seasoning. It's proprietary information that's kept private, right? So as long as you keep it private and it gives you an edge, you kind of automatically have these trade secret protections. And they're not filed with the government, because obviously if you filed it, it'd become public information, wouldn't be a secret anymore. Another example kind of in our industry would be chartreuse, right? Nobody knows the recipes for chartreuse except for these two Carthusian monks. They keep it a secret for a reason. It's protected. Don the Beachcomber famously batched his cocktails, or put, has symbols on bottles instead of labeling the bottles. Don's, mix number 2. These were all different ways to keep things secret, right? Kind of a example of how you would lose, trade secret protection is the famous case of the Lynchburg lemonade, which is now a Jack Daniel's trademark cocktail, but it was created by this guy named Tony Mason. He was in a bar, he created this drink, became super popular, and Jack Daniel's wanted it, and they said, "Hey, like, we want to use your cocktail." And they went back and forth. Jack Daniel's ended up reverse engineering the drink, came out with their own Lynchburg lemonade, which had sour mix instead of lemon juice. And the guy sued. So, Tony Mason sues him, says, "Hey, I had a trade secret. You guys violated my trade secret. What the hell? Like, you guys got to pay me." Went to the court. Ultimately, the court ruled in Mason's favor, but only gave him nominal damages of $1. The guy appealed, went to the appellate court, came down for a new trial. And in that second trial, he actually lost, which was a surprising result until you looked at the facts. And it turned out that this guy didn't actually keep his recipe a secret. Turns out that he told everyone and their mother when they investigated the bar. Even the dishwasher knew the recipe. And it was one of those things where he just said, "Hey guys, it's a secret," except, when you tell 100 people your secret and tell them it's not a secret, or it is a secret, it's not really a secret anymore. And therefore he lost trade secret protection. So if you're going to go the trade secret route, be like Don Beachcomber, don't be like Tony Mason, right? Copyright, I'm going to go into really quickly because there is time, now a lot of us are writing books as bartenders, and a lot of menus are very elaborate, and those things can be copyrighted and copywritten. Books are copyrightable, but not recipes, right? A book of recipes is not copyrightable. But if you give a creative spin to a recipe, right? If there's language that you're using to describe the ingredients or the process, and there's images or drawings that accompany those recipes, that book of art becomes copyrightable. And it might be even the way you talk about the cocktail, right? If there's a story behind the drink, let's say we took what Andrew just did with a dark and stormy, translated that into words, made a transcript, created a book or a pamphlet, that would be copyrightable. His words would be under copyright. And so if anyone copy pasted that, put it on their website, there would be, legal recourses available. And then lastly, trademark. I think it's one of those cool, sexy sounding things like, "Oh, I'm going to trademark my cocktail." But what does it really take? I think it's one of those things that on paper, and when you look at it on non-practically, it sounds like a great avenue to protect yourself. But, with any recipes and cocktails can be, trademarked. They need to be registered with the U.S. Patent Trademark Office, the USPTO. And it's not the easiest thing to do with beverages. The patent office is really good at like logos and words and phrases, or sometimes even red bottoms to shoes. They understand products. But when you say, "Hey, there's a recipe for this drink," it does become very hard for them to understand. And the other thing with trademarks is you also do have to protect it. I think a lot of larger companies that protect their trademarks, they get a lot of, flack for sending cease and desist to a bunch of small mom and pops here and there. But it is a requirement to keep your trademark. And I know, Andrew, you guys have a little more insight on what it took for Dark and Stormy to register and keep their trademark, right?
Yeah, I mean, I think when Malcolm first trademarked the drink in 1980, he had no clue what he was getting himself into. And I remember an old article from the New York Times that was, "Would you do it again?" And he's like, "Not sure," and the reason for trademarking the drink is really to protect the integrity of the cocktail. So if you come to Bermuda and enjoy Dark and Stormy, you go back home to LA and you order Dark and Stormy there, it tastes just like it did when you're in Bermuda. And we also started making Dark and Stormy ready to drink in Bermuda in the early 80s as well. So I think Goslings was a little bit ahead of its time when it came to the ready to drink version of the cocktail. And in 2011, we introduced the current format, which is now available globally as well. And Yeah, it's quite a feat protecting the trademark. And the one thing to keep in mind is we're never going to go heavy-handed into a bar or restaurant. It's really our job to get out there and educate people about the Dark and Stormy and why it is a trademark cocktail. Where we have the challenge is if another rum brand is trying to trade on the equity of the Dark and Stormy, and we have to be a little more aggressive, I suppose, with our approach and that particular brand.
I mean, you guys famously took on, I don't know if I'm allowed to say their name, but it rhymes with Lernaud Picard.
Yeah, we did, and there's a great case study there, which was in our favor as well. Yeah.
Yeah. That said large company had a Dark and Stormy on their website with, a rum named after a place in California. And you guys took them on and you won, right? And you made sure that the Dark and Stormy name stayed with Goslings, which is important. And in terms of that, I think you touched on it. There is, with any legal action, I think this is very important. Sort of winning the PR battle on top of that, right? It wouldn't be a great look, and I think as bartenders get, there is a little bit of fame and prestige that comes, with the territory sometimes, right? But I don't think, for example, Sam Ross, if he, trademarked the penicillin and he went around suing every young bartender who made the penicillin, probably wouldn't be Sam Ross that we know and love today, and wouldn't be the global icon. Nor would that drink be on every menu I've ever been to in Asia, right? So it is one of those things that it is a balancing act, and it can go wrong. We've had another run. There's a lot of rum companies with trademarks. With Painkiller, with Pusser's Rum, and there was a sort of famous backlash, a couple years back, when Painkiller New York had to change their name to PKNY because they got sued, right? We got sued, and it was one of those things where, I don't think they intended to go viral in that way, but it was a thing that it was met with a very big backlash, and that can happen. And then lastly, going into, if you are a consultant or if you are, coming in as a beverage director and you have all this IP and you have training materials, you have recipes, you have prep guides and all these things, how do you protect that IP? And why is it important? There's a couple scenarios. One is you're coming in kind of an outsider. If that relationship ever sours, how do you prevent an ex-client, let's say, or a client from taking your works and continuing to use them without necessarily paying you? Or if they haven't paid you, how do you take away kind of that access? Or if you're opening a bar as a bar owner, you have partners, and let's say you don't want to go on and open more projects with these people. Or maybe it's the other way. Maybe you want to keep opening different projects and your investors, just wanted one pet project, and you have to go seek new investment. And, he says, hey, actually, I own the rights to all this IP when you're the one who created it. So how do you keep that kind of vested in, how do you keep a vested interest in those things? And this, again, goes kind of into the software world. And it's, the idea of licensing, right? Of keeping the IP ownership under your name, but allowing others a license to use said recipes. I think a couple, industry figures have kind of moved into that realm where they grant licenses to their IP, whether it's, recipe menus, training material, operating, standard operating procedures. Those are things that really can, fall into heavy IP protection. If you think about software licenses nowadays, you don't actually own software anymore, right? Microsoft owns Word, right? You just got to use what they give you. Google owns Android, right? Apple owns iOS. You have a license to use that software, but they can pull that, they can pull any features And it's one of those things that, I think we can learn a lot from and on our side. I think there's a great example is the Jerry platform by Proofing Company out in Asia. They have a training module that's, online. The bartenders log in, they have, lesson plans, everyone, it tracks your progress, et cetera, et cetera. But the other thing is it's a subscription-based training platform. So once the client pulls or once the training, contract is over, the client no longer has access to those materials, right? Or they just, a lot of times they'll just keep paying to keep access. I think as a personal, on my end, I keep everything in Evernote and I share my notebooks, right? And then it's very easy to unshare them afterwards, right? Someone wants to come in and copy paste, a bunch of recipes and a bunch of material, I guess, I can't really stop them, but it does offer some sort of protection, right? And to write that into your contracts and be like, hey, if this doesn't happen, you lose your license to use our IP, right? And if they're caught using it, again, there are legal recourses that you can take. So hopefully this was informative, in terms of, how to protect yourself legally when it comes to your intellectual property in our industry. And yeah, I'll hand it back to Andrew to close out.
Copywriting is a really hot topic. So we're looking forward to the question and answer segment coming up. Cheers. Thank you for your attention. Good day. Welcome to the question and answer segment for navigating the dark and stormy waters of intellectual property. My name is Andrew Holmes, brand director for Goslings Rum, joining you live from Bermuda in our barrel aging warehouse where it smells incredible. And we're joined by our expert panelist, Mr. Daniel Eun, who's in LA. Might be a little early for a cocktail in LA at this moment, right?
A little bit, but it's 5 o'clock somewhere, as they say.
Yeah, well, I was just going to say it literally after 5 o'clock in Bermuda. So I'm going to start by making it dark and stormy, but really excited to be here live with you guys for the question and answer period. So up on the top right there, there's a chat. Please plug in some questions into the chat, and Daniel will narrate the questions, and we will both do our best to answer them with all the knowledge we got.
Cool. Yeah, so while you make that, we just got our first question coming in. So it says, can you speak to some of the best practices for new brands and bars to clear possible names to avoid claims of infringement? The USPTO makes it really easy. You go on their website and you can look up any trademark on their trademark search function. That's actually the first thing I advise clients to do whenever they're looking to look at names. And it's also you can do the same thing for business entities, right? In California, you can look up, you go to the Secretary of State, see all the other businesses that are using your name. Those names might not be trademarked, but they are used in trade and they do have a claim possibly for use of that name. So it's good to know if anyone else is, using your great idea for a name in any sector. All right. So I would always say, look it up, see if there's an other LLC or an S corp or business entity that's using that name. And then 2, look through the trademarks. You just do a search function real quick, uspto.gov, I believe. It's like the TAS search, TEAS. You do a basic word search, put the word in, click it, and it'll show you all the different trademarks. That being said, if they're not in your industry, you can, technically register a trademark within, that sector. There's different classes of trademarks, whether it's beverages, jewelry, automobiles, right? So you can have different sectors, right? And so, but yeah, the best way is just to go online and search and do the due diligence. There's also law firms that will go and do it for you. But if you really want to go into the nitty gritty, there are times when sometimes trademarks that sound very similar will be rejected. That's happened to clients of mine in the past, and so sometimes it is recommended to get actual legal expertise. That being said, I didn't say this in the pre-record, but I am barred. I am barred in California. I'm not barred anywhere else, and I am a lawyer. I am not your lawyer, right? So this is all legal disclaimer that should have been said. But yes, this all doesn't constitute legal advice. This is information, and we'll leave it at that. Next question: what is aging in the barrels behind you, Andrew?
Oh, that is a great question. So aging in the barrels behind me is a mix of rums. You might be able to see there's chalk writing with a code on each of them. So here in Bermuda, we age for our Goslings Family Reserve Old Rum. So some of the barrels back there are aging for Old Rum. And then we also age for Goslings Papasio Single Barrel Rum, which we have just been bottling for the 2020 release of the Papasio Single Barrel. So that's obviously done one barrel at a time, whereas with the old rum, we'll vat many barrels together to make that blend annually. So it's a once a year bottling, but hundreds of barrels come together to make that one blend, whereas Papasio is an expression of a single barrel bottled one at a time.
Cool. So this came in. So it takes a lot of time and investment to protect a trademark. Do you think it's worth it financially? I mean, I think obviously it is for you guys, but if you want to speak on that,
Well, I mean, it depends. I think if you ask Malcolm Gosling that question in 2020, was it worth it financially? And he added up all the lawyer bills over the decades, because the trademark, as we mentioned in the pre-record, dates back to June 9th, 1980, and was first registered here in Bermuda, and now registered in other jurisdictions around the world. So it obviously takes a lot of resources to be able to protect the trademark. So it is, one of those things you have to take into consideration is, are you prepared to protect this and to fight for it? And, we talked a little bit about it before. We have to pick our battles, right? And if another brand is trying to use the equity of that trademark and for their purposes, that's when we have to really be firm and pursue it. But, if there are bars and restaurants that are printing lists with Dark and Stormies using other rums, that's our job to get out there and educate them, not to get legal with them, So that's kind of, it has worked very well with protecting the Dark and Stormy. And I firmly believe that having the Dark and Stormy trademarked has helped Goslings grow the flagship Black Seal rum brand in export markets around the world. So I believe that the trademark has benefited the rum in that sense. And it wasn't until 2009 that we introduced Goslings Stormy Ginger Beer, but it's not a trademark that you have to use Goslings Black Seal Rum and Goslings Stormy Ginger Beer. The trademark simply states Goslings Black Seal Rum and Ginger Beer. So that also, I think some people get a little bit confused, is, that means that you can't mix any rum with ginger beer, and that's not the case. There are hundreds of rums that are absolutely delicious with ginger beer. But the combination of Black Seal rum and ginger beer is so unique, and that name Dark and Stormy, that we want to make sure that if you're going to call it a Dark and Stormy, it tastes good, made with Goslings Black Seal rum.
Cool. Let's see. How do you balance? I guess this is a good add-on. How do you balance protecting your intellectual property without becoming heavy-handed and litigious?
I mean, it is a tough balance. And I know you cited an example from your personal experience with Painkiller
right.
in New York. And that was an example of where they came across too heavy-handed and realized afterwards that that wasn't the approach to take. And, Goslings is from Bermuda. We're laid back down here, right? We enjoy rum and the whole lifestyle down here on the island. And, we're not an aggressive company in that regard, So I think our approach when we go into a restaurant is really education. And, if they don't know it, then that's on us, that we haven't gotten the message out to them, that they haven't, known that the Dark and Stormy is trademarked and should be made with Black Seal rum. So right. I think that's the approach, is to just come in and educate them. And, 9 times out of 10, when we go in there with that attitude and that vibe, they're very receptive, and we'll say, okay, and we might offer to reprint a menu, or, next time they change the menu, get it corrected, or, it doesn't have to be right away, or anything like that. And then there is that odd occasion where the bar or restaurant owner just may not be willing to change or reprint at all. And sometimes, you just got to pick your battles, and sometimes those particular instances are not worth getting aggressive over. And there are other bars and restaurants that we need to educate on the dark and stormy. So we have to prioritize that as well.
Totally. Yeah, that's a good follow up. What should someone do when they get a cease and desist letter, and how to best respond?
That's definitely in your court.
Yeah, it's a good question. It's one of those questions that's hard to answer without more specifics. It really depends on who issued the cease and desist letter, right? Is it a generic letter, or is it pointed, right? That would be the first thing I would look at. If a client came to me with a letter, and I would, you read it. If it's a major corporation that's, sending out 100 of these, every day, the response might be a little different than if it's, a mom and pop who, has found out that, you're there, and, they're, because like you said, a company like Goslings might pick and choose their battles, and you might not be a battle that's worth it for them, right? One, right? And it depends on how blatant is your violation, right? You might truly believe you're not violating a trademark, and it might be worth, fighting it on your side. If you look at the facts and you're clearly in violation, then, sometimes the best thing to do is just be like, mea culpa, like, we'll change, and usually with the cease and desist, it doesn't come with a financial threat initially anyway, right? A lot of times it's just like, hey guys, stop doing it and we won't sue you.
Yeah.
Because most companies don't want to go through the cost of litigation. Litigation gets expensive. Cease and desists are really cheap, right?
And, just thinking that name or sending a cease and desist letter, just to reinforce, like, we've never sent a cease and desist letter to a bar or restaurant, right? We've never done that in the whole history of the trademark. So that's certainly not something that we intend on doing or taking to that next level. There was an instance of a brewery in New Brunswick, Canada, called Picton's Brewing. And they had a beer expression of theirs that was dark and stormy. That was the name of the beer. So, obviously we were alerted of this violation. And, when it's another entity like a brewery using the name dark and stormy, if we let them get away with it, it could end up diluting the mark to the point where we lose the grasp on the trademark. So we had to send them a cease and desist letter, and which they complied with and took the beer off the market. Obviously, there were some consumers of this beer that were quite upset, and I can appreciate why they would be upset. However, what the owner did was really smart, is he rebranded the beer Cease and Desist, and then reintroduced it, and it became his #1 selling expression. And the customers that were upset are now happy because it's back on the market. And, that was a great way of taking a negative and really spinning it into a very positive situation.
Yeah, I mean, yeah, I guess that's the best. That's like a best case scenario for sure. But yeah, I mean, in terms of responding, if you do find yourselves in that situation, I would say find legal advice. If that's what every lawyer will tell you. But it really comes down to, do you feel like you're in violation or not? And if you are, sometimes it is better to follow the law. And if you don't, and you really do think you can fight it, that's why trademark cases exist. For a lot of times. Or you might think that you are not in violation because your class is different, right? Like you might have, I don't know, a cocktail called Coco Chanel, maybe. I don't know if that's, like, just to throw it out there. I think a lot of people do. And you might be like, hey, you guys only have the only trademark in fashion, and cocktails don't fall into that category. It's therefore I'm allowed to use it. Whether that's true or not going to get into that, but you might have an argument there, that a bar is separate from whatever industry that the trademark holder is in. And so again, it's one of those questions that are really hard to answer without having more details.
Yeah. No, it just made me think of, outside of the beverage category, our dark and stormy trademark also extends to food products.
Mm-hmm.
We've had dark and stormy rum cakes that we've produced over the years, and sauce, and confectionery jam and things like that, and we actually had a case in Bermuda with a local jam, calling their jam Dark and Stormy Jam, and it didn't
Mm-hmm.
contain any Goslings Black Seal rum, but the label that it contained Goslings Black Seal rum. So we obviously had to send them a letter to cease and desist, and we were
Right.
successful in getting them to rebrand their jam to something other than Dark and Stormy Jam. But yeah, for food products, we have licensed the name Dark and Stormy to a number of food product items.
Mm-hmm.
Tips Scoop ice cream makes a Dark and Stormy ice cream, but obviously it contains Goslings Black Seal rum, and they're licensed to use that name. And it's a really, nominal fee that Goslings receives for that licensing. It's not like we take, a big percentage of sales or anything like that. It's just so that it is legal and they're able to use it, and we're registered. Well, it's been registered. So yeah.
Totally. Let's see. Anything to think about when running a theme week? Star Wars themed cocktails and movies. Or what about the Stranger Things bar targeted by Netflix? I think it again, the scope and scale will definitely depend on if a company comes after you or not. Again, not legal advice, but with all things legal, right? Nothing's illegal until you get caught. I mean, it's kind of like the
Yeah.
not legal advice, but just saying, right? If you do it and no one says anything, then did it really happen, right? So that is something to think about. Like if you're a small bar in a smaller market, right, and you're gonna attract maybe 100 people, and it's gonna be a cool thing to do for your guests. I'm not saying that they won't, but most large studios aren't going to come after that kind of thing, right? They understand that, people appreciate, the content that they create, they created, and maybe it could be something more collaborative, right? I don't think, George Lucas is going after every bar out there that has like an R2D2 cocktail on their menu. I think it's more, it's complementary, right?
Yeah.
It is different when there's major money involved, like that the Stranger Things bar pop-up, that it almost looked like Netflix or Stranger Things or the production company was involved in creating it, right? And that's where the level of confusion comes in. If I have a theme park, right, and instead of being used to studios, I create one that has a Jurassic Park world, and it's clearly themed. It has, the animatronics, it has all these things, and it looks like, Universal was behind it. They're going to have issues with that, because not only do they have to, protect their trademark, you might be doing things that they don't want their brand to be involved with, right? Necessarily. And so, there is kind of a cusp of, I think, on a practical scale of, when people are going to come after, infringement, and with copyright, there is fair usage, right? Like, a lot of times when you look at YouTube videos, right, you are allowed to comment, right? You're allowed to critique, you're allowed to use certain things, you're allowed to have video clips on your content where you're using copyrighted materials, as long as it falls within fair use, right? Whether a cocktail name falls within fair use or not is going to be, I don't think anyone's really tested that in the courts. Yeah. And again, I think it would be different in scale, right? I think that's the biggest thing. But yes, I mean, I think the Stranger Things bar, just from my legal opinion, they've pushed it to a level where Netflix couldn't do anything but respond, right? There's PR behind it, it's getting press, kind of on a national level. They had taken a lot of the thematic elements of Stranger Things to the point where a regular patron could be confused and think, oh wow, like Stranger Things is doing this pop-up, versus, oh, this is like a bunch of bartenders who really love Stranger Things and they're doing, like an homage to
yeah.
to
There was
the
in
show.
Toronto, there was a Harry Potter theme bar, but it didn't have any of the fonts or the signs or anything like that, but the cocktails were inspired by the movie, and it was just kind of a almost gimmicky thing, but it was extremely busy for the several years that it was open. But everyone knew it as the Harry Potter bar, even though it wasn't called Harry Potter, but everyone knew
Right.
that was inspiration for the bar. Yeah.
Totally. Says, what do you think are reasonable rights to retain over work done as a consultant for restaurant groups? For example, rights to publication. I think that really depends on your relationship with said group. But definitely, publication rights. I am a huge advocate of licensing your, IP when it comes to, training manuals, compendiums, things of that nature, unless, they pay you enough that, you say, you know what, all the work I do for you, like you can take, right? Like if they're paying you whatever it takes to make their bar manual, and it's going to be that restaurant group's bar manual from now till maybe forever, right? And you're okay with that, and you're okay with putting the work in, and whatever they pay you is worth that money, then I think you sign all those rights. And if it's not, I think that's something you license and hold on to. I think when it comes to rights to publication, again, same thing. If these are cocktails that they're paying you to create for them, and there's a monetary amount that you're okay with, right, signing over that right, I think it is wise. I mean, you don't always have to do it, but it is wise to be able to be like, hey, anytime you publish this recipe, you have to at least credit me as your consultant, or as the creator of the cocktail, so you do get the publicity, and you do hopefully further your career. um Again, these aren't necessarily legal considerations. These are just practical business considerations to think about. But again, if they don't pay you for the rights to the cocktails, and it's not a thing, then I think it's one of those things where you might license a cocktail to them, right? And be like, hey, like I retain the rights to use these cocktails anywhere I work at, and you can use them while you're paying me to be your consultant. But as soon as I leave, like I'm pulling my bar program.
Yeah.
It always depends on scope of work, right? It depends on the scope of how much you're getting paid, and if it's worth it to you or if it's not. And so, these are very individual questions that you should ask yourself. But yeah, I mean, if someone's paying you enough money, or paying me enough money to, write them a book and write them a bunch of recipes, and they want them forever, like that's one price, versus, me retaining the rights to it. It's another.
Yeah, it's
Right?
important, I guess, when you're starting out with a new establishment and they've asked you to do this work, to really keep all that in mind when you're getting into it. Because it's one thing to do the menu and then come back to them afterwards and be like, oh yeah, I want the rights to this, like it has to be done at the very beginning of the process, right?
Totally. And it, again, I think this is another thing where it depends on where you are in your career, right? If you are starting out, sometimes it's harder to ask, for those things, and you become labeled as difficult, and so again, this is part of like the, as brands need to think about the PR value of going out being aggressive, and sometimes within a career you do have to recognize where you are in your career. And so yeah, it is definitely harder to ask for these things early on in your career. I think later it becomes easier, and as your work becomes more valued. um, but I think it's also important to stick up for yourself in the beginning as well too. I mean, don't let someone roll you over just because they have more money, right? Like that seems to not be the smart thing to do.
Definitely, definitely. So this just makes me think about Instagram, right? So if I'm
Oh yeah.
a bartender, I'm building my career, and I post one of my signature recipes on Instagram. How does that work? Are other establishments or other bartenders able to use that recipe freely? And obviously, there's a copyright to the image, perhaps, but the recipe itself how does
Yeah.
that?
I mean, we're in a completely new world with social media, and the amount of information that's being shared, and how it's being shared in the platforms that we're sharing on. And a lot of it is unexplored, right? But from just looking at it at face value, if you post something on Instagram, number one, yes, you do retain the copyright to the image, right? The image is clearly copyrightable. Most likely the caption would be as well, if there's some sort of creative spark. Again, if you're writing something interesting, and it's not just a list of ingredients, right? If it's a list of ingredients, unfortunately not copyrightable. But if you're like, hey, I thought of this cocktail, this is my inspiration for it, these are the ingredients I'm using, blah blah, I combine these flavors, that copy, the text is also copyrightable.
Yeah.
That being said, you've posted it on Instagram, and Instagram as soon as you post something on Instagram, you own the image, you own the copyright, but Instagram automatically, you basically granted them like a free license to use your image. And so Instagram can anytime, repost your image, reuse it in their advertising. And that's the right that you give up by posting on Instagram, right? It's part of their terms of usage, right? The only way to get around it is to not post it on Instagram, you know? And I looked it up a little earlier today, and that's literally what it says. Like, our license, the license that you grant us ends if you delete your account or delete the photo, right?
Wow.
But if someone else has shared it, then it's too late. Like it'll like basically if someone else has already shared it, they're not going to take it away, right? So you basically hope that no one has ever shared it. When it comes to other people using your recipe, then yes, they can use your recipe, unfortunately. And a brand could as well, right? Whether they, the biggest thing is technically if you're another account is reposting on Instagram, they need to at the very least give credit, right? I think there's a legal right to that. But there's not a ton of there's not a ton of repercussions that you can come after, someone for reposting your photos, right? Which is unfortunate. Yeah. But you see a lot, yeah.
If someone put up a really cool cocktail with Goslings Black Seal Rum, and they tag Goslings Black Seal Rum, so that's how we come across it. If we share that cocktail, we say, this Daniel's cocktail that he created, or put him out there. So then there's a chance that Daniel will get the exposure from the network of Goslings, and it's a really
right. I mean that's the positive, right? A way to look at it. And a lot of people do create their brands and get their identity out there. And sometimes the end goal is not that one post, but to be recognized as innovative, cool bartender. And then maybe that does lead to consulting jobs and different things, right? So there's it is something that you should be cognizant about, but just because you're not just because you're giving up legal rights doesn't necessarily mean it's wrong to do, right?
And there's no way to trademark a hashtag, right?
No, I think you can, but not that you can't really trademark the use of the hashtag, right? So you can trademark it as a word, right? Like, so if you had hashtag, I don't know, blessed or something, right? And some company was the one who thought of it, and they wanted to trademark it, and but once it's out there in the world, like, and the whole point of, I think it flies in the face of trademark law almost, right?
Yeah.
In that the whole point of having a hashtag is for it to go, viral, and for people to be using it freely, and for that to to go after people for using your hashtag with a bunch of cease and lists kind of defeats the purpose of having your hashtag, right? So it's
exactly,
maybe in a way to prevent other brands from tagging onto it, but even then the power of a hashtag comes from making sure the branding is recognized with it, right? And that's the homework that you have to do on social media, and not necessarily rely on courts to do that, I would say.
Good point.
Let's see. Can you talk about the role of influencers and the legal risks? Note FTC enforcement has been stepped up and the fines have increased. Yeah, I mean, have you guys had any, I don't know, legal issues with influencers? Let's say, with the Dark and Stormy, or is it something you guys have even thought about?
I mean, there's certainly been media that have written about it and cited other rums, and we've had to get we call it a recall, or what's the word I'm looking for, where you ask them to rewrite it with the I can't remember the name, retraction. That's the word. You ask for a retraction if the media has run. In terms of influencers, no, I don't think we've had any specific cases where an influencer has been using the Dark and Stormy trademark inappropriately. No, I can't think of anything.
Yeah, I don't know if we've actually answered that question, but Whoever asked the question, if there's a way to clarify what you mean, that'd be great. But I think yes, with I mean, is it influencers in terms of using other people's trademarks, or the risk of being an influencer? And I guess yeah, I just want a little more clarity on the question. Whoever asked it, so if you can chime in again, that'd be great. Let's see, we have said we just got a notice. We got 5 minutes left. So legal risks.
So Daniel,
Yep.
what's your thoughts on cocktail competitions, right?
Ooh.
Now,
Yeah.
I know it's kind of a loaded question here, but you know,
Yeah.
in the context that you know, obviously, if you're entering that competition for a specific brand or you're creating a recipe that you're proud of, you think it's an award-winning recipe, you go to the competition. You know, do you think that the brand now owns the rights to this recipe and can use it whether you're a winner or not?
So a lot of that actually comes down to the competition rules and regulations. You know, I've written a couple of them, and I've read a ton of them. And some competitions, they do take ownership once you've submitted it, right? And sometimes that makes sense for that brand, right? And they're compiling recipes, and if there's a winning one, they want to be able to publish it and you know, ride the coattails, right, and promote it. Other times, you know, all they do is they just retain the rights, right, to publication, right? You give them a free license to any images. A lot of times when you, I don't know if you noticed, for a lot of people, even when you walk into the room of a cocktail competition, they say, you know, you kind of have like the right to your image, right? Like if they take pictures of the room, you know, they're allowed to take, you know, take your picture. They're allowed to, you know, take videos, and they're allowed to publish it and use your image in any given, right? So a lot of times you do give away these rights.
Sign a waiver, right? Yeah.
I think again, it's one of those things where if you're okay with it and you're entering this competition, you know, with the best intentions, then for sure, you know, go for it. You know, I think it's again, it's different from America and internationally as well too. It's one of those things where I've noticed that, you know, a lot of times the competitions, you know, in LA or New York, it was, you know, it's a lot of it was for bragging rights between ourselves, right? And then once my career took me abroad, I realized that winning a competition, you know, let's say in the Philippines or in Singapore or whatever, is the ticket to getting a visa to a more lucrative market, whether it's to go to Hong Kong or to come to America and to really, you know, up the, you know, the level of income that you could bring to your family. And so it's a very different ball game. And so again, it's very individual. It's one of those things where I think you should read the competition guidelines. Also to, you know the rules of competition and how you're going to win, right? I think that's important. I feel like a lot of people don't read the rules. So I mean, again, it's as much as you can educate yourself on that, you know, competition if you're okay with it and you want to win, and you know it can promote you as a bartender, then you know, then go for it. And if you're not comfortable with it, then it's, you know, there's other paths, you know. Oh, okay. There wasn't. It's an influence. Sorry, but the influence question. It's in relation to use and control over influencers and how they impact a bar brand. Oh, I think this might be in terms of like how much control you control your influencers. I'm guessing, almost like, are they? I'm guessing if it's like more of like, are they employees slash independent contractors? If you're using them for marketing, that opens up a whole different, I guess, ballpark. But it's being litigated right now, and it's being propositioned right now in California. So we'll see how California answers that. And every market's different, so it's interesting, the fine line between employees and contractors for sure.
Yeah, definitely, definitely. I was just saying, when we do enter an agreement with an influencer, there's a very clear set of guidelines that we're expecting from them, and that they're expecting from us as well. But it's just, you know, about having that conversation at the beginning of the exercise.
For sure. Yeah, one of my friends slash clients, she, you know, runs an agency, and there's a style guide, there's a posting guide. It's very explicit, whereas before it was like, yeah, just like one post, one story, and you're good. And now it's she sends them brand guys. They know exactly what they're getting into, and it's a very different ballgame. It's becoming very sophisticated now,
and very lucrative.
Yeah, and very lucrative. Cool. I think we're just about out of time. So
Awesome.
yeah. I mean, I want to say thank you for everybody. Right.
Yeah.
Thank you, Andrew.
Thank you everyone for tuning in. And Daniel, it's always great to chat with you and learn. I'm learning more every time we talk as well.
Yeah, same. Yeah, and if you have any further questions, what's the best place to reach you?
Email aholmes, AHOLMES @goslings.com, or you can find me on Instagram @441BDA, which is our area code in Bermuda and our airport code. Or obviously
Awesome.
@Goslings Rum as well. You can always find me through our Instagram there.
Cool. Yeah, and if anyone has any follow-ups, you can find me on Instagram as well. Talking about Instagram @MakeSayEun, MakeEmSayEun, or email me esquire@DanielEun.com. So yeah, so I guess that's it. We'll be signing off.
Well, cheers to the dark Stormies.
There's actually a way to improve on Gosling's slowly aged Black Seal rum. Added to Gosling's finely spiced ginger beer. Result: a trademark dark and stormy.